Hobish versus AXA.
Good afternoon, Your Honors. May it please the Court. I'm Gary Malone, representing plaintiff appellants Richard Hobish and the Hobish Trust. May I reserve 5 minutes for rebuttal?
Yes.
Thank you. Your Honors, the Hobishes allege that defendant and respondent, AXA Insurance Company, victimized the late Mrs. Hobish, first by deceiving her at the age of 82 into obtaining a life insurance policy with false representations of minimal risk of premium increases, and second, by breaching that policy when she was 91 by imposing a gigantic premium increase that targeted the elderly, despite its contractual promise to treat Mrs. Hobish equally and equitably with younger policyholders in her given class of non-tobacco user. The Appellate Division affirmed the Supreme Court's summary judgment rulings, which held that the Hobishes could not seek actual or punitive damages from AXA for the loss in value in the policy under either a breach of contract or a claim of deceptive business practices in violation of General Business Law, Section 349. In other words, the Appellate Division held an insurance company...
Did it actually say, I'm sorry, did it say you could, the Appellate Division say you couldn't recover actual damages, or did it say there were particular types of damages you couldn't recover?
The decision is a bit obscure on that point, Your Honor. The Supreme Court said that we could not recover compensatory or consequential damages. The Appellate Division said it was affirming the Supreme Court, but not reaching the issue of what other damages, if any, are available. But the damages that the Hobishes were seeking were actual damages based on the loss in value of the policy. In other words, basic...
Well, you were, if I understand, you were,
yes.
On the breach, let's just take the breach first. You were seeking the death benefit under the policy less the payout. Is that right?
We were seeking the value of the policy, which is calculated by the death benefit minus the expected premiums over the life expectancy of Mrs. Hobish and payments that in her own policy account that the
It had been recovered, that had been recouped. Yeah.
Right. And that is just...
And the
yes.
Appellate Division said you could not recover that.
Exactly.
But did not say you couldn't recover some other measure of damage for the breach?
That's correct, but it's unclear from the Supreme Court's decision if it was actually leaving anything in, because it said it was granting AXA summary judgment on the Hobish's claim for compensatory and consequential damages. So it kind of left us in a murky area here, Your Honor. But the true measure of damages...
But the
yes,
defendants were not granted summary judgment on liability.
Exactly.
So you still have some sort of claims pending, both of GBL 349 and a contract claim.
Yes, though again, in that the Supreme Court said there was granting judgment on compensatory and consequential damages. That certainly sounds like it's not allowing any type of damages. It's unclear what the court meant by that.
Well,
and yes.
Before Supreme Court, did you have a theory of damages in addition to, with respect to compensatory and consequential, other than the full value of the policy minus, I assume, the payout and the expected premiums? I think you just referenced the expected premiums.
Right. That was the only damage theory that the Hobishes put forth under the authority of this court in the Conley decision, for example, that said that when a policyholder has a breach of contract for a life insurance policy and is uninsurable, the measure of damages is the value of the life insurance policy measured by the face value minus such things as the premiums over the life expectancy.
And so if we were to conclude that you can't get the full value, are there damages that you have sought other than the full value of the policy under the, as compensatory and consequential, setting aside the 349 claim for a minute?
The only damages that the Hobishes were asserting were value of the policy, in other words, benefit of the bargain damages.
Right. And with respect to that, are there any cases that you can point us to where a plaintiff was allowed to recover full value of the policy, minus whatever is on the other side of the scale, expected premiums, a payout, et cetera, where there was not a wrongful cancellation?
We do have a case in the, I believe it's the Western District of Washington. And the
But
end of
nothing in
case
this,
that's, I'm
nothing
sorry?
in New York?
Nothing in New York. But I'll point out the cases in New York, they state as a general principle that when there's a breach of contract that the policyholder is suing on, and in most of these cases, it's a case where the insurer has breached, or let's say terminating the contract. But these cases don't say, okay, this measure of damage is based on the fact that the insurer has terminated the contract. What these cases say is that measure of damages is based on the fact that there has been a breach of the contract. And when there's a breach of a contract, the non-breaching party has the right to terminate the contract and sue for full benefit of the bargain damages.
Okay, so to be clear, are you alleging, I thought you were alleging that there was a wrongful termination here.
Well, we're alleging that there was a substantial breach by AXA, which gave the Hobishes the right to terminate the contract under basic contract principles. That
So you do concede, though, that you terminated the contract?
I certainly
There
do.
was a cancellation?
Yes.
And what would get you the benefit? I would assume that whatever the measure of damages is, or whatever the right type of damages are, it's measured from the point of the breach, correct?
Yes, but it's measured by what the value of the policy was at the
Why
time
is
of the
that?
breach.
Because my thinking is if you canceled the policy, the face value of the policy is no longer relevant because you're not going to be able to recover that face value because the policy's canceled.
Well, the question is, what was the policy valued at before the breach? What was the policy valued at after the breach? And as a result of the breach, the contract lost more than $1 million in value. And we estimated it was $1.5 million. The defendant's expert estimated that if you accept that measure of damages, it could be up to $1.2 million in loss in value. And
So is that your measure of damages, the loss in value at the time of the
yes,
cancellation?
and we say that the measure of the loss of value at the time of the termination of the contract is the face value minus the amounts received and the premiums that you would expect during a
Why
life.
wouldn't,
Can I
why wouldn't,
ask-
I'm sorry, go ahead.
No. With respect to the emails among the family members, why should that not lead us to conclude that what happened here was that the family members decided to take the cash value, if I'm using the wrong terminology, you'll tell me, but, you know, to essentially cash out the value of the policy for their own family economic reasons as opposed to because there had been, as you say, you know, a substantial breach by the insurer?
Well, Your Honor, I think what you're talking, though, about is the same thing. Because what the family members decided was, my God, they're increasing our premiums by a huge amount. This is financially injurious. We can't take this. And so, yes, it's a financial matter because we can't take this financial burden that the company is trying to impose on us. Yes.
They could have continued to pay the premiums, presumably. They also, presumably, and I realize this is expensive and perhaps arduous, but they probably could have sought some kind of injunctive relief as well. So there were arguably options available to them. So what are we to make of their decision to take the course of action that they did, given what they say about why they did it in their own, you know, emails?
Because, Your Honor, when a party is faced with a substantial breach that has imposed substantial financial penalties, the party has a right to say, okay, I don't want to incur these penalties. I'm going to cancel the contract. The courts don't say to people, okay, you have to keep on paying these premiums and go bankrupt. Otherwise, you have no remedy.
But there's
yes.
sorry,
yes.
if I understand the way the contract works, there's a couple of things, I guess. One is that they did terminate the contract, but they also, at the same time, sort of enforced it in that the return of the cash was pursuant to a provision in the policy that allowed them to do that. It was only because they were standing on that provision of the contract to be able to get the money back. So they were, yes, they were terminating under protest, but they were also relying on it. The other thing is, at least if I understand the way the contract works properly, if I properly understand the way the contract works, sorry, adjective in the wrong place, there was about a little more than $500,000 of cash value, and the policy would have allowed the premium payments, or more appropriately, the difference, the increase that you're complaining about, to be paid out of the cash value for some period of time while you could have either brought a declaratory judgment action or injunction or something like this and avoided the consequence you face now. I mean, I realize in retrospect it would have turned out to be a great decision to do that, but you didn't have the benefit of foresight.
Right. Well, first, Your Honor, the Hobishes did not enforce the contract by terminating it. And
They enforced it by demanding the $500,000 back.
it's not so much demanding. AXA had no right to the money. This is like if
Under the contract.
Well, Your Honor, if I have my money at a bank and a bank engages in embezzling and I find out the bank is defrauding people, if I ask for the return of the money in my bank account, that doesn't mean that I'm now reaffirming my relationship with the bank. AXA had no right to that money, and AXA's own executives admitted that. I'll point out that
Well, except they actually took something like, I've forgotten the number, a $30,000 or $40,000 deduction, which is different from the bank, I think, because that's what the contract provided.
right. But I'll just quote some testimony, Your Honor. Mr. Tizzoni, whom we deposed, an AXA executive, said that he was describing what a surrender of a contract is. He says, a surrender is when someone has positive value in the contract and they choose to end the contract, get the value paid out to them. And
This
he
contract had a surrender value, over here, this contract had a surrender value separate and distinct from the death benefit amount, did it not?
says, yes, but that's because the Hobishes had put in money into an account. It was essentially, they were treating it essentially as a savings account as well.
But isn't that
yes.
exactly why they were enforcing the contract? They were taking that money out,
No, because what the contract provides is that when you end the contract,
right?
and it's over, AXA has to give you your money back because it has no right to it. And the testimony I just quoted from Mr. Tizzoni, that's at A2931 of the record, and at A2993 of the record, he says that when a policy is surrendered, AXA is giving the client their money back.
So why wouldn't
the
you have
contract is
been,
ended.
why wouldn't you have been made whole by getting that surrender, whatever it was worth, plus, I suppose, whatever amounts you were overcharged for whatever period the overcharge existed for on the premiums or COI, whatever it is. And, you know, under my understanding of contract damages principle, that would have put you roughly in the position you were in when the breach occurred. Why is it not adequate?
It wouldn't actually put you in the same position, because the position you were in was that you had a life insurance policy that had a value of something over $1 million. Both sides agree to that.
But we all agree
And-
that policy was canceled. You could have you could have taken your money from the surrender value plus your overcharge damages and bought another $2 million policy somewhere else.
And paid even greater premiums at the age of 91, Your Honor. That's why the Conlue decision of this court said that when there's a breach of a life insurance policy, the insured has the right to cancel the policy and get benefit of the bargain damages measured by the value of the policy measured by the face value of the policy
I guess I'm
minus
just
the
struggling,
premiums.
counsel, because the
Yes.
benefit of the bargain you're talking about requires a death, which hadn't occurred. And that
Well,
just,
not-
I can't get past that logical leap.
It's not just that, Your Honor. The benefit of the bargain here is that you have a life insurance policy that has a certain value because they've made all these payments in it over the years. And you can calculate that benefit by saying, okay, it's expected that if your life expectancy is the average life expectancy, you're going to end up paying this amount in premiums. And by paying this, if you subtract that amount, that's the value of the policy. That is its economic worth.
Could I ask you
Can I-
about the GBL damages?
Yes.
Because I understand there's two components. One, we've essentially talked about, same as the contract damages, at least the way the appellate division thinks about it. But you also had asked for restitutionary damages, I think, under the GBL claim?
We asked for both actual damages
Yes.
and restitutionary. And I'll point out, the courts below said, well, because you don't have a breach of contract damages here, you don't have GBL damages, which, Your Honor,
Can I ask you
frankly
what
makes
your-
no sense.
What your
Yes.
theory of restitutionary damages is?
The theory of restitutionary damages is essentially based on the forfeiture doctrine, that an agent or an employee who is unfaithful does not have right to keep any of the profits that's made. And we say that you can easily calculate here which should be considered the profits that AXA had,
And have the
and that
court-
portion should be returned.
Have the
But that's-
courts?
I'm sorry.
No, have the courts decided yet whether or not restitutionary damages are available under 349?
No, not yet, Your Honor, but the courts have said that the Attorney General has the right to essentially
Right.
seek restitutionary damages under 349, but not
How
private plaintiffs.
easy would it be to calculate AXA's profits? Because they were providing life insurance for a period of time, and there was some mortality risk associated with the insurance they provided, and had Ms. Hobish passed away while the policy was in force, there would have been a recovery. And at least as I understand their financial analyses, which I don't know if they're true or not, but take for a moment that they are true, their underlying problem here is that they were undercharging people given the mortality risk for this group of people, including Ms. Hobish. So they may actually have suffered a loss rather than made a profit, even for the period of time the policy was in force.
Well, we say that the profit that AXA made on this policy can be calculated by looking at the cost of insurance, which is essentially the minimum payment they were asking for people, and subtracting that from the amount of the Hobish's account balance, which AXA would have been allowed to keep if the Hobishes had not terminated the policy. And if I could just point out that with respect to the actual damages that we're seeking under 349, even if the courts below were right that the Hobishes should be considered to have waived the right to breach of contract damages, that theory has no application to General Business Law Section 349, which is designed to fill in gaps to make sure that people who are deceived, even if they don't have a breach of contract claim, can say, okay, these are my actual damages.
Is your theory of what the actual damages are comprised of any different than the full value of the policy theory under the breach of contract?
No, it's
claim?
the same value, but it's based on a different theory. Under the 349 claim, it's that AXA deceived the Hobishes by saying the minimal risk of damage, minimal risk of rate increase, when their own business record said they'd already started planning a rate increase. And the breach of contract, obviously, is based on the fact that there was a contract that said we're going to treat you equitably of all people in your given class, and they failed to do that. And I'll point out that the court below also erred by not giving a summary judgment on the breach of on the liability for breach of contract, because the contract plainly says you're going to be treated equitably.
The federal court actually thinks that there's an issue of fact on that, right, as to the class?
Yes, but its basis of doing that is saying, well, both sides had reasonable interpretations of the contract, but
Same
AXA's,
contract, right?
the same contract, but AXA's basis of its defining the meaning of given class is based on an actuarial standard, which obviously the Hobishes do not have any knowledge of. And this court has many times held to determine if there's an ambiguity of the contract, you ask, what is the reasonable expectation of the average insured person who's not going to have any idea of what actuarial definitions are? Plus, this court has said that if there's two different meanings, you have to go with the meaning of the average insured person unless that's unreasonable. And the court below said that wasn't unreasonable, Your Honor.
Thank you.
May it please the court, my name is Larry Krantz, and I represent Equitable Financial Life Insurance Company, formerly known as AXA Life Insurance Company. Your Honor, starting with the breach of contract damages, I think the questions that the court posed essentially summarized our argument.
Counsel, under the appellate division's decision, if we look at that, what damages remain? Liability clearly has not been decided. So
Correct.
if it went back under the appellate division's determinations, what measures of damages would remain available to the plaintiff?
Yes. So the reason that that's a difficult question to answer is because the plaintiffs have only put forth one damages theory, which makes no sense.
But
They have only, that's all they've asked for.
I take it you mean the full value theory?
The
face
death
value.
benefit minus some adjustments.
Right.
So
Could they put forth, I'm sure you're much more familiar with the procedural intricacies of the case than I am. Could they put forth other theories of damages if it went back and there's a determination of liability?
They can certainly try. We would have to see what they put forth and whether we opposed it or not. But
Of course.
Well, I guess Judge Halligan's question may be, my question is, would you oppose that on procedural grounds or just substantive
Yes.
grounds?
truthfully, it's hard to answer until we know what it is that they attempt to do. And perhaps they attempt to amend the complaint. The complaint only alleges one theory of damages. Throughout the case, they litigated one theory of damages. We thought that theory was wrong, so we moved for summary judgment,
Counselor?
striking it. I'm sorry.
Is there ever an instance where, when the insured cancels the policy, that they could potentially get the face of the policy? Or is it only when it's the opposite, that is, the company cancels?
It's hard to eliminate all possibilities. I can't think of one standing here now. Perhaps there's a
So
bizarre fact pattern that could arise.
So
but-
is your view never or maybe?
Well, it would have to be a completely different case, and I can't fathom
Just
what-
not here?
Certainly not here. Here, we have a voluntary surrender of the policy for financial reasons of the plaintiff, an invocation of the surrender terms of the policy. This money, contrary to my adversary, did not.
They claim, over here, they claim that the insurance company created the circumstances that forced their hand to surrender the policy. So it's not truly voluntary. You may disagree with it. This is
Yes.
just the theory, right? That therefore it was not a voluntary surrender. Under her own choice, she would never have done that. But that's the argument. But for the breach, what they allege is a breach.
And of course, we disagree with the factual
I
predicate,
understand.
but under any circumstance, you still have to analyze what are the damages that flow from a breach.
So let me give you,
In this
let me give
case-
you a hypothetical that is not this case, okay? 20-year level term life policy, right? $10,000 annual premium for whatever the face value, whatever that will buy me at age, well, I don't want to say what age I am. But you got my hypothetical so far?
I do.
Okay.
Forgive me, Your Honor, I have a little hearing.
Sorry, I have a
apologize.
little voice problem, but I'll go louder. 20-year level payment term policy, right? Premium payment is $10,000 a year, death benefit is whatever it is. Year 3 of the purchaser makes the, insured makes the payments for the first couple of years. Insurance company breaches the contract by saying the premium now is $100,000 a year, right? Clear breach of the agreement.
Yes.
Insured says, okay, well, then I'm canceling the policy. It's midway through the year. Give me back my $5,000 partial premium, which the insurer does, right? And the insured dies a year later. And the estate says, we would have had this large policy in place, but you breached the contract. Why can't I get back the death benefit?
Well, in my view, under those facts, which are quite different, as I think
Yes, they
Your Honor
are.
admitted or
They
agreed,
are.
the proper course for the aggrieved policyholder would be to immediately file suit for breach. And if they truly could not continue to pay the premiums under the new crazy increase that everyone agrees was wrong,
Right.
they would have to get, or they would seek injunctive relief that the policy does not lapse, that they are permitted to pay the pre-existing agreed-upon premiums of $10,000, and that the insurance carrier may not lapse the policy because they are in breach.
Would that be true under 349, and if so, why?
I don't see,
I mean, it would be under I think, the terms of the chief's hypothetical, that would be a deceptive business practice. It would probably also be a breach of contract, but it would be a deceptive business practice. And so if they did what the chief suggested and simply got the pro rata amount, I think that was what he was suggesting, paid back, would they not have a 349 claim? And the question would just be what the damages might be?
they might if they could establish that it was consumer-oriented
Right.
and all the
All
other parts of
predicates of a
349. But under 349, the damage issue doesn't change. Under 349, they're entitled to actual damages Under breach of contract, you're entitled to compensatory damages. We are not aware of any authority suggesting those are different concepts. And if you look at the 349,
What if they, in the hypothetical, and even in this case, they argue, we can't get any other insurance. We're now locked out of this particular consumer industry. We can't get any more insurance.
yes, so
So we're in a worse place than we were when we first purchased the policy, when
But-
perhaps they could have had options.
I think there is an important answer to that question. I'm going to bring it back to these facts because it's easier for me to explain my answer. Ms. Hobish had insurance at the time of the increase. She did not need to go into the market to get a new policy. She was insured. She was not uninsurable. She was the opposite of uninsurable. She was presently insured. All that had to happen is that the policy had to remain in effect. So if she had she had 3 years to do nothing,
Right.
policy would have just paid itself.
Yeah.
She could have gone to court and tried to get equitable relief, but left the policy in place and have been insured. The whole idea of in conlu, the prong of,
Is the risk there that as money is being taken out to pay for these premiums from that pool of funds that's available to her under this arrangement with the insurance company, it's losing value, and the risk is I may lose in that litigation, and now I've got less value than if I just, I don't know if the numbers, you can tell me if the numbers are wrong, than if I just involuntarily surrender now under protest in the hopes of arguing this later.
I think that is true, that is the risk, that you will lose and you'll be wrong that it was a breach of contract and now you will have lost value. But that is a risk that everyone must determine if faced with what they believe is a breach of contract.
When you say the
Anyone in
policy
that
value
position.
would have paid for 3 years,
Yes.
that's without any payments, not without
Nothing.
the payment that she had been making and that she believed she was still entitled to make. Is that right?
Correct.
So do you know what it would have been had she made the same payments she had been making previously? How many years it would have bought in that circumstance?
The problem with answering is that her payments were not continuous at a given rate.
Oh, you mean she hadn't been making them, but
She missed,
Right.
when the Madoff crisis
Yes.
happened to her, she missed a couple of years of payments.
I see.
Then there were sporadic payments, so there's no
The
real
policy on its face,
continued-
though, has the planned payment of something like 34.6, some number like that, I think, right?
I'm not sure what is,
On the,
forgive me.
on the face of the, right on the front page, I think it says planned annual payment, and there's a number, and I think it was
Oh, yes.
something like 30.
No, I can explain that to you.
No, I know what that is. I'm asking, had she made those payments, what the 3 years would have been 4 years or 5 years, or what would it have been, had she made those starting at the point where she alleged a breach?
If she had continued making those payments.
Yes.
It would have been extended several years. I can't honestly tell you how many.
Okay.
It's a complicated internal actuarial calculation, but it
Okay.
would have been extended.
Would have been more than the 3, but we don't know.
Several years,
Okay.
more than the.
But
than
that's
the
because
3.
the difference would have been made up between whatever she continued to pay, whatever that amount is, and drawing from the account, right? That, to make up for the increased payments, premiums,
Correct.
excuse me.
The
That's how you get to, well, it would, her money would go long, would last longer, gain her more time, right? Because she's still drawing, you're still drawing from the funds.
Yes, I mean, the fund would be worked down, and if she added money to the fund.
Right.
It would be worked down longer.
Right.
That's the way the policy worked.
Yep.
But to be clear,
Yep.
this is not a bank account. This is not the equivalent of a bank account. This is a contractual right to a surrender payment. There is no account in her name where the money is sitting like a bank. These are general funds of the insurance company,
And-
but under the contract, if she makes a proper surrender under the terms of the contract, and in our view, thereby affirms the existence of the contract, she gets the
So
surrender payment.
just to be clear, from your position, she had, I think you're saying only two options. Well, I guess three. Surrender, get whatever she's going to get from that, which is what she did under protest, file a lawsuit, and pay or not pay, right? That's kind of why maybe it's three, pay or not pay, file a lawsuit, seek a PI, whatever she's going to seek there.
She
But
could wait
those are her
3 years
paths.
before
Make your
paying.
own choice with respect to the insurance company or seek judicial relief, right? That's
Well,
the
she-
choice, as you, I thought that's
Yes.
what you're saying, as
I
a
think
legal
that's-
matter.
I think
This is
that's
the
right.
only
Her
way you're going to get
choices-
damages.
Her choices are to accept the increase or seek legal relief against it,
On whatever theory she wants to argue.
whatever theory she wants, just as anyone who's facing a perceived breach of contract can do.
On liability, counsel, what do you say to your adversary's argument that in deciding whether the contract is ambiguous, we can't look at evidence, you referenced the actuarial definition of class, that Ms. Hobish presumably would not have had familiarity with or access to?
So a couple of points there. Number one, Ms. Hobish testified at her deposition that she never read the policy. So we are not dealing here with an actual claimed understanding of what terms meant.
Right, but I think he's making a distinct point, which is that I don't think there's any allegation that she knew about the actuarial definition of class, and that that's not readily available. So what is your response
Yes.
to that?
Anyone reading this policy, in our view, would not equate given class and rating class.
But
as
you
the
relied
same.
on the actuarial definition, I believe, did
No,
you not?
we rely on multiple levels. Our
That is one thing that you relied on, if I
Yes,
am-
but our first level argument is, of course they're not the same. They're two different terms. No one would think two different terms mean the same thing in a contract. They're in different clauses of the contract, several pages apart for different things. So to us, the face of the contract does not support the argument that they're equivalent. Now, we moved for summary judgment that our view was unassailable. We lost. Both parties lost on the ambiguity question, and we have not pursued that in this court. We have accepted there are now 7 judges who have read this policy. The trial court judge here, Judge Maisley, the 5 judges in the appellate division, and Judge Furman in the Southern District of New York.
And what is the status of the federal court action?
Settled. But just to conclude my thought, our point is after 7 judges have told us it's ambiguous, we have dropped the argument, and we accept that we have to go to trial on that issue because it's ambiguous. If no further questions, I think I'll rest on our papers with the rest. Thank you.
Thank you.
Your Honors, the counselor said that this was a voluntary termination. Nothing could be further from the truth. As we show in our briefs, AXA manufactured this situation. AXA for several years studied how can we improve our finances by getting
Counsel?
elderly. Yes.
What weight, if any, should we give to the fact that DFS looked at this and said that these were not exorbitant or inappropriate charges, that they represented a legitimate basis for the increase?
This actually goes to our Section 349 claim, because what AXA did here was deceive DFS. AXA sent DFS a letter saying the only reasons for this increase are because of our changes in estimation of our mortality and our finances. But if you look at AXA's records that we cite, they said that one of the primary reasons they did this was because the surrender of policies by elderly people had decreased. They lied to DFS. That's why DFS passed on this, and this is part of their deceptive practices. They also told consumers the only reasons we're doing this increase is because changes in mortality expectations and our investment experience. But again,
liability is not in front of us now, right?
I'm sorry?
The question of liability, you still have your claim, right?
Well, we still have our claim that is
This
more or
doesn't,
less
the
cut-
DFS, what you're telling me about DFS goes to fraud, essentially, not to the measure of damages?
It goes to fraud, Your Honor, but the courts below said there's no claim here for punitive damages, that there wasn't enough evidence of AXA's wrongful conduct, and that should be reversed. We show that at the very time that AXA told its agents, including Mr. Levy, who spoke to Mrs. Hobish, and the testimony is undisputed that she relied on Mr. Levy, he told her there's a minimal risk here of any rate increase, and he said that AXA told him to say that. We show that AXA's manuals told him to say that. And at the very same time, AXA's records show that they decided, you know what, we have to increase rates on the elderly because we goofed up. We didn't figure that there'd be so many elderly people signing up. This costing us too much money. Their own records say that they decided that
Is it signing up, or is it not canceling, not terminating the policy?
It was a combination. The too many elderly people had signed up. They were too successful in marketing this to the elderly, but also then not enough elderly were ending up surrendering their policies. And so AXA made it, and we cite business records where they say, it's been decided, it's on our books, we are going to be increasing rates on the elderly at some point. And they delayed that. They said, we're going to study this further. But they never said, we're getting rid of this decision. And that was deceptive to do that and not tell their salespeople, hey.
And so how does that get you to punitive damages?
Because it was deceptive, Your Honor, telling people that, hey, there's minimal risk here of
Well,
rate
do you
increases.
automatically
Yes.
get punitive damages on a GBL? I mean, to prove a GBL claim, you're going to have to prove deception, right?
Yes.
That's an element. So do you automatically get punitive damages if you prove your claim?
No, Your Honor, because we can prove deception without proving actual fraud. We say there's actual fraud here because AXA knew that it was going to be increasing rates, and yet it let its salespeople go out and still say, don't worry, there's minimal risk here.
Does the policy have a provision that caps the rate per $1,000?
I'm sorry,
Does the policy have a provision in it that caps, that sort of guarantees your rate per $1,000 can be not be more than this ever?
Yes, that amount was not reached.
Never reached.
Never reached, but the record is undisputed that Mr. Levy told Mrs. Hobish, don't worry, there's hardly ever any rate increases, we're not aware of any, there's only minimal risk here. And Mr. Levy actually broke down and cried when he actually found out that Mrs. Hobish's premiums were being increased from $63,000 a year to $164,000. And he wrote to AXA's top executives saying, you know, how can this be happening? And they basically told him, well, we have the right to do it, so we're doing it. Get out of here. And I'll point out, Your Honor, the fact that AXA actually did manufacture this situation and decided it wanted to force people to either give up their policies or pay a greater amount is allowing AXA to benefit by its own wrongdoing. This court has continuously reaffirmed the principle that no one should be permitted to profit by his own wrongdoing. And that's what AXA is being allowed to do here. And with respect to the question of whether or not there's any decisions saying that you can get the value of a policy when it's not been canceled, I'll point out that in our brief, we cite the Ennin case from the Western District of Washington, which said it doesn't matter if the insurer cancels or not. The question is you just look at the value of the policy. And that's the principle that this court followed in Conlu. And I'll just point out that in other contract situations, such as the Latham Land case, which we cite in the Third Department, there the court said a plaintiff whose property has been decreased in value because of a breach in contract is entitled to cancel that contract, to terminate that contract, and sue for the loss in value. It's a basic contract principle. And counsel, when he says, oh, well, Mrs. Hobish should have just been forced to keep paying this until she went bankrupt, that is totally inequitable, Your Honor. That's not the law in New York. People who have experienced a substantial loss in value because of breach in contract should be able to sue that. And there's no principled basis here on which to deny Mrs. Hobish that right, or the Hobish family at this point. Thank you.
Thank you.